Glendale City Council for September 25, 2012. Roll call.
Council members: Friedman.
Here.
Manukian.
Here.
Najarian.
Here.
Weaver. Mayor Quintero.
Here. Your report, please.
Agenda for the September 25th, 2012 special meeting of the City Council was posted on Thursday, September 20th, 2012 on the bulletin board outside City Hall. Before you today is the Director of Human Resources regarding a report on Pension Reform Bill AB 340. 1A is a motion to note and file the report. Also, we have the Director of Human Resources, item number 2 on the special meeting agenda, Memorandum of Understanding, MOU, between the City and Glendale Management Association, GMA, on behalf of fire sworn managers. 2A is a resolution amending and extending the MOU commencing September 25th, 2012 through June 30th, 2016.
Mr. Ochoa.
Yes, sir. With the assistance of Mr. Doyle, our HR Director, we will provide you with an overview and a compare and contrast with our own situation of the much heralded state pension reform package. We have looked at it somewhat with a bit of a jaundiced eye, if only because what was adopted amid much fanfare really doesn't hold a candle to that which this council has done. And I think it was Mr. Najarian who had said a few weeks ago quite astutely that if we don't tell folks exactly what Glendale has done to put us ahead of the curve, then we can't really expect anyone else to do that for us. And so we want to make sure that certainly, I think the council knows much of this information, but that the public has it as well, that which was approved by the state and that which you have already done in advance of what the state was endeavoring to do. So with that, Mr. Doyle, if you want to take us through the presentation.
Certainly. Thank you, Mr. Ochoa. Mr. Mayor, members of the council, this item is a note and file item. I'm going to attempt to go over the new pension reform bill that was passed by the state. We have a PowerPoint presentation, so we'll go through it with that. At this point, there is still a lot of ambiguity in this law. It was only signed less than 3 weeks ago, and I've been to a few training programs on it and read as much as I could about it. But I think the attempt here is to give as good an overview as possible. Before we do, I want to provide a little bit of a historical context, essentially why this has occurred. And you all know, as you're aware, the situation that CalPERS is in this day and age, the investment portfolio losses, the stock market declines, which have led to investment returns that are well below what the anticipated returns were for CalPERS. And it's led them in a situation with a great unfunded liability. Many have said that CalPERS is, in its current state, unsustainable. City of Glendale, I want to just briefly talk about our assets and liabilities relative to our pension system. As of June 30th, 2010, we have approximately $1.1 billion in assets compared with $1.3 billion in liabilities. So we are certainly in the situation that many agencies are in, but probably better off than most for the reasons that we'll talk about.
And it's worth noting there, because that number gets thrown at the council and at the viewing audience quite a bit in terms of what the $1.3 billion in liabilities represents as an actuarial liability. If everybody walked out the door, the value of all of our liabilities at one moment in time is that $1.349 billion. But what often is left out in that discussion is the fact that there's $1.144 billion in assets. And as any actuarial will certainly tell you, I am not one, but certainly we meet with them quite often, the idea that everybody walks out the door and cashes in at the same time just is not existent in reality. And so it's important to make sure that we give both sides to that coin. There are significant liabilities, but there are significant assets at the same time.
So our liabilities exceed our assets? Basically?
As most agencies do today, yes. But again, I think that my point would be that when you hear a number like $1.349 billion in liabilities, without any kind of context that there's $1.14 billion in assets, it starts to paint a much more stark picture than somebody would otherwise be able to realize by what the council's done previously.
Does that include all the assets that were incorporated into the financial statements as a result of GASB 34?
This does not include the OPEB, I do not believe. Does that?
Does that include all the assets?
Is this our OPEB liability as well, Jason?
Yeah.
Let's see.
Okay.
Give us your name for the record.
Jason Bradford, Finance Administrator. This only reflects the pension liabilities. This does not reflect the OPEB liability.
Yeah, so it's just a pension line.
Yes, sir.
And,
Correct.
and for those listening in, OPEB
Other
is
post-employment benefits.
such as,
The value of retiree medical, who are allowed to blend their rates along with active employee rates. That creates an implied subsidy on an actuarial basis.
was that an actual liability, though?
The way that GASB is coming out, it will be. It is today. We will start to have to show it on our books.
My misunderstanding, this is just for the pension. It's
Correct,
not
sir.
the financial statement as a whole.
Correct.
Thank you.
Okay. I'll point out the actual costs of the pensions as it pertains to the remainder of our budget. Our personnel-related costs are approximately 35% of the total budget, and that rises to approximately 87% when you're just specifically talking about the general fund budget. Of that, pensions are approximately 11% of the total personnel costs when looking at the citywide part of this, and about 13% of the general fund personnel costs. Now, those figures are a bit high at the moment because this is all based on the adopted budget, fiscal year 12-13 budget, without all of the reductions of the positions that we've had since September 1st. And Finance will be back in a few weeks to offer an amended budget indicating those reductions.
This indicates a deficit of approximately $200 million as of 6/30/2010.
That's correct.
Do we have the figures for 6/30/2011?
We will have that, I believe, with the upcoming CAFR for the last fiscal year.
You don't have it internally? We don't keep track of it?
I'm sure we do, but I don't have that here with me.
Okay. To continue with the historical context, what you're looking at here are the employer-charged rates that CalPERS charges the city of Glendale. And you'll note some of the historical perspective. As you can see, these rates fluctuate from year to year. And right now, as our PERS rates look somewhat high, they were actually higher back in the 80s around that time. You also see around 2001, they fell to zero, and they were at zero for probably 2 to 3 fiscal years before CalPERS started to jack them up again. All of this is related to really the losses, investment with CalPERS, stock market reductions. As you can see, towards the end of the 1990s, the stock market was doing very well, and then all of a sudden, in the mid 2000, 2008 in particular, we started to see significant losses against what our anticipated returns were going to be. Talk a bit about the actual Pension Reform Act, AB 340. As a preface to this, Governor Brown, in October 2011, it was one of his main priorities as a governor to do something about pension reform. He did pass or introduce a 12-point pension reform plan back in October. It, however, faced immediate challenges right from the get-go. Number one, he had a legislature that was in opposition to many of the elements of that particular plan. And number two were some legal limitations. This whole idea of the vested rights doctrine, which I'm sure many of you have heard of, this is the notion that pensions are vested rights from the moment a public employee is hired to the time of their retirement, and that right cannot be taken away. This has been challenged in the courts many times, and it's been essentially upheld. And had this program passed in the method that the governor had wanted it to, it would have faced significant legal challenges and probably would not have passed in its current form. One of the major elements of the governor's 12-point plan that never made it to the pension reform bill that ultimately passed was one that would require hybrid plans where you had a mixture of a defined benefit plan and a defined contribution. But once again, that got somewhat watered down in the context of the negotiations over this bill. So, Artie? AB 340 was, again, worked on this past August, mainly between the legislative leaders, the governor's office, and lots of the unions were involved in many of these discussions. It was ultimately passed August 31st, 2012, signed by the governor on September 12th of this year. And again, most of its provisions take effect January 1st of 2013. Again, as a preface, I do want to remind, as Mr. Ochoa said, some of the things that the city of Glendale has done to prepare for these types of situations, and remind about the many actions that have been taken over the years by the city to deal with this. I want to talk a bit about the whole issue of cost sharing as it regards the employee share and the employer share of our CalPERS obligations. As you may know, CalPERS is funded by two means. One is the employee share, which is a fixed amount. Typically, it's either 7 or 8% for what we call miscellaneous employees, and 9% for our safety or police, fire, sworn employees. City of Glendale, probably for the past 20 years, has required its employees to pay the full employee share. Again, 7 or 8% with regard to miscellaneous employees, 9% for our sworn safety.
And that is unique among independent cities, highly unique.
Very few agencies do that. Nowadays, since many of the cities are facing significant budgetary issues, they're starting to negotiate, starting to require their employees to pay a portion of that employee share. The next bullet reflects the actions that we've taken to negotiate agreements with our employee associations to pay a portion of the employer share. And again, the employer share is that larger amount that helps fund the PERS system that fluctuates from one year to the next. And again, the city of Glendale has been at the forefront of this back as early as early 2000s, requiring our employees to pay a portion of the employer share. As you can see from the PowerPoint, we have our GCA employees paying 1.5%. We have our firefighters paying 2%, and that will slowly increase to 3.5% by January 1st of 2015. Our GMA employees and our executives pay 3%, our GPOA 3.5%, and IBEW 0.5%. Again, as I was saying earlier, some agencies are starting to see have their employees pay a portion of the employee share. Still, to this day, very few require them to pay into their employer share. Additionally, some of the things we've done over the years, and I think most of this council was involved in our efforts to add second tiers for our existing employees. We've gone from 2.5 at 55% to 2% at 55% for our miscellaneous employees. We've gone from the 3 at 50 to the 3 at 55 for our police and fire sworn safety employees. And in addition to that, we've gone with the 3-year final compensation formula as opposed to the single highest year formula for all of our new hires.
And the takeaway then is that on the 2-tier, the council has ensured what the outside costs are for your employment costs, but also with the cost sharing, you're taking a big chunk out of what the immediate short-term real-time costs are. And what you don't see, and what Matt was talking about with the state, is that they really are generally looking at the outer years by the 2-tier program, as opposed to incentivizing agencies to get to where we are today.
Okay. Next slide gets into the specific provisions of AB 340. And the first and probably most significant is the introduction of new retirement benefit formulas, where the formulas are actually reduced and the ages are actually increased. What you see, and this would apply for all new hires after January 1st of 2013, is the imposition of these new formulas, miscellaneous. And by miscellaneous, I'm talking about non-sworn employees, your librarians, your clerks, your engineers, They would fall under a new plan, which is essentially a 2% at 62 plan, where the minimum retirement age goes from 50 to actually 52. And at 52, the percentage would be 1%. So it's essentially a 1% at 52, 2% at 62, and it maxes out at 2.5% at 67. Next, there are 3 what we would call safety plans, again, for sworn police and fire employees, starting with what they're calling the basic plan, which is a 1.426 plan at age 50, and that would max out to a 2% at 57 plan. There's option 1, which is a 2% at 50 plan, which maxes out at 2.5% at 57. And option 2 is a 2% at 50 plan, which maxes out at 2.7 at 57.
At what point in the hiring process or employment process does the employee make that decision to opt for any of the options?
Mr. Mayor, it's not the decision of the employee. It is the City of Glendale will have to adopt one of those 3 plans.
Okay.
And as we understand, as of today, we believe that we would be required to utilize the plan that's closest to the one that we currently have without going over that, which is the option 2. That's our understanding thus far, but I've heard conflicting information on that. But option 2 would be a 2.7 at 57 plan. And a lot of things go with increasing the retirement age, where you have people working later in life. There could be some concerns about injuries and workers' comp situations, so it's there may be some concerns in that respect. Additional element, and again, this is an important part, is that all new hires after January 1st, per this legislation, would be subject to the average 3-year final compensation, which, as we pointed out here, is something that we've already done in the City of Glendale. Employee cost sharing, new hires after July 1st of 2013 would be subject to pay 50% the normal cost of the pension.
January.
Say July or January?
I meant January. Apologies. January 1st of 2013, it would be a 50% cost sharing of the normal costs of the pension. The normal costs is actually, it's an actuarially derived amount. It's determined by CalPERS, and it's supposed to represent the 1-year costs of our respective pension plans. So it's about half of what our employer rate ends up being. That's what the normal cost is, and it's to be distinguished from the amortized costs. And with regard to that, well, I'll go on to the next bullet. As it relates to existing employees, the city and the employee may collectively bargain to have employees pay 50% of the normal costs by January of 2018. So there's really 2 levels of this. New employees hired after January 1st, 2013 will be required to pay this 50% of the normal costs of the pension. Those current employees, we have the option of negotiating with them an increased amount of the cost sharing to ultimately reach 50%. The important thing to take out of this is that we are very much ahead of the pack with regard to our existing employee cost sharing provisions. In fact, if you look at what we're currently requiring as far as our miscellaneous employees, we're probably already there. With regard to our safety employees, we're probably just a little bit shy of being there. And whether we want to get there with our safety or remain there with our miscellaneous is largely a public policy decision, which we'll have to take.
Matt?
Yes.
If it turns out that our miscellaneous employees are actually paying more than they would under the state plan, does that mean we have to still adopt the state plan and they'd be paying less?
Mr. Mayor, Councilmember Friedman, that's a good question. And my belief is that because we have negotiated, and we've negotiated something in excess of what is required, that we would keep our current cost-sharing provisions in effect.
But we don't know for sure.
I've gotten conflicting information on that. So, and I would hate to think that an organization such as us that has been so good in being out ahead in this cost-sharing area to somehow be punished, because that would end up being a loss for us of money. If we were to have to lower that cost-sharing, that would mean the city would have to pick up more if the employee is picking up less. So that's something we'll be watching. But I believe, and it's our intent, to maintain the existing cost-sharing provisions, certainly for our existing employees. And
There's likely to be some cleanup on that front, requiring cities to put it in their own trust fund, any overage that's there, because those rates may fluctuate over time, and so they just want to hold on to it. But also on the slide that's on the screen now, I think what you may end up seeing, if those are truly the compensation caps, and I won't steal Matt's thunder, I mean, you're going to hear about that in a second, that you may start to see cities experiment with more exotic types of retirement packages, particularly for executive personnel, if that's what the max out is, which actually goes against the transparency that is presumably at the heart of the reform, and it works at cross purposes.
Okay, continuing on. Again, the previous two provisions are probably the most significant. The ones that I'm going to address are additional elements of this, which the first being a compensation cap, and this would apply to, again, new employees hired after January 1st of 2013, essentially place a cap of either $110,000 or $132,000, depending on whether someone participates in Social Security or not. Most of our employees who have worked here their entire career are not participating in Social Security, so they would likely be held to the higher cap. This figure, the legislation does say that this could be subject to an adjustment based on CPI at a much later date. Okay. Some of the other provisions relate to restrictions on post-retirement employment. Again, following the effect of this bill in January of 2013, individuals who retire from CalPERS will be required to sit out for at least 180 days, which is roughly a half a year, before being eligible to be rehired into another PERS agency. And this would prevent individuals from essentially retiring one day and then starting up the next day in some sort of a part-time capacity. There is an exception to this. If there is a position or role that's critically needed, it would have to come before that jurisdiction's elected body in an open meeting, and that declaration would need to be made and approved by the legislative body. But it's clearly intended to reduce the double dipping that some people have.
Does that include the employees who have recently retired under our program? Would be coming back hourly?
No. We believe that this would apply to anyone following January 1st of 2013.
But following that, it would apply to all employees?
Yes, yes. If one of our existing employees were to retire in July of 2013, then they would be subject to this.
But it doesn't apply to someone, it doesn't apply to someone who begins that program now, but then after January, they can still continue, in other words? In other words, they don't have to retire after January.
That's correct.
I mean, they do have to retire after January. If they retire now and they're hired back as an hourly, starting January, they could it's not the case that wouldn't apply, right?
Not without some declarative statement of need by the body, by the city council.
Okay, so I'm confused. I'm confused about whether they have to actually retire after January, or whether this takes effect whether or not they retired after January.
If you retire after January, you have to sit on the sidelines for 180 days before you come back.
But I think the question is, if someone retired this month or last month,
Right.
and then come January 1st, do they have to stop working for the city altogether?
Exactly.
And I think Mr. Doyle's answer to that question was no,
Right.
because they came in before January 1st.
So how about someone who had retired and then comes back to Glendale in a salaried position? Do they still collect their PERS retirement and the salary?
If someone retires and then comes back as a salaried employee, they would have to reinstate employment and give up their pension. And to the degree that they've received any of their pension, they'd have to pay that back in order to become a salaried employee.
Is a council member a salaried position?
There are restrictions on council members, elected officials, but I would need to research that further.
So they may have to pay back?
If
I mean, you don't have an answer for me, I know, but one scenario,
you retire from CalPERS and begin collecting your pension and then reinstate in a salaried capacity where you're working over, it's 960 hours in a given year, then you would have to reinstate and pay back whatever pension
That's brutal.
you'd received.
That is brutal.
Okay. Another item in the AB 340 is the elimination of airtime. Airtime is essentially it's unqualified service credit that currently employees can purchase in order to add to their service time. It's quite expensive. It can cost anywhere from $20,000 to $40,000 for each year of service that you attempt to buy. That will be eliminated under the provisions of this new law. There were some questions asked about whether military service credit will be allowable, and that will continue to be part of this, because military service is actual time spent in service as opposed to the airtime where you're just buying essentially service time out of thin air. So the next bullet relates to the elimination of retroactive pension increases, and again, this means if there are any future enhancements of the existing retirement plan, which I doubt any city would do that in this day and age, but if there are, those improvements would have to be done on a prospective basis, not on a retroactive basis. So it's an example. If I'm a 20-year employee and I've spent 20 years under one plan, and then that plan gets improved, and I spend 5 years in the improved plan, my total service credit isn't going to be applied on that new plan for the whole 25 years, just those last 5 years. So no more retroactive pension increases. The last bullet relates to the elimination of pension holidays. This is when we were looking at the employer share, how it fluctuated, and there were some years where the city paid zero into CalPERS. This legislation will stop that to where each agency will have to pay something depending on what the actuarial tables provide. So there will be no more pension holidays. Okay. These last two provisions relate to, really, these were inspired by some of the shenanigans that went on with the city of Bell. Forfeiture of pension benefits upon a felony conviction. That's for any public official or employee who is convicted of a felony in the relation of the job that they do in their official capacity, that they would have to forfeit their pension following that. The second bullet, and this is actually a good protection, and this is a provision that protects employers from the city of Bell style spiking. Essentially, if you have an individual who is making a certain amount in one agency, they move to another agency in a similar capacity, and their salary goes up dramatically, the employer that they go to will be largely responsible for the actuarial liability of that increased cost, as opposed to the previous employer, which is the current situation or the current state of the law. All of the employers that individual worked at have to pay some part of what those costs would be, even if it's another employer jacking up the salary to reasonably high amounts.
So that protects the city of Glendale.
Would.
Case.
Yes. Okay. So just to summarize, those were sort of the major highlights of this. If you think about it, the AB 40 is really just the adoption of a really massive two-tier program, and that's what the state is referring to when they call it reform. A reminder of what Glendale has done over the years, going back as far as the 80s and 90s with the cost sharing and the various other things that we've adopted in the second tiers. And I think the takeaway is that had the state adopted the Glendale model, certainly years ago, we'd probably not be in the situation that we're in. So with that, if you have any questions, be happy to try and answer them.
Questions? Mr. Weaver?
Certainly.
And just very good job of laying out the story. Mr. Ochoa?
I was just going to say, sir, that being in this organization for a good period of time, coming up in this organization and leading this organization as a council, as a staff, I think sometimes it's difficult to maintain a perspective on where the rest of the market is. And I can't say this enough, that the council and that the leadership of the administration have done an outstanding job of getting to a point where everybody else is trying to get to. In the next several years, you will see considerable strife in labor markets in the public sector for folks trying to do what you have done over the last 2 decades. It has to be stressed. And I don't mean to sound like a cheerleader, but I'm telling you what, it is very rare indeed. It's very unique to be where Glendale is today.
Okay, any other comments? Thank you very much, Mr. Doyle. Next, please.
It was a motion to no file, so.
And a second.
Second.
Roll call.
Council members: Freeman,
Yes.
Menuchyan,
Yes.
Najarian,
Yes.
Weaver.
Yes. Next, please.
Next is a memorandum of understanding between the City of Glendale Management Association on behalf of fire sworn officers.
Mr. Doyle.
Okay. Mr. Mayor, members of council, this item is a resolution adopting an amendment to the Memorandum of Understanding between the City of Glendale and the Glendale Management Association on behalf of its fire sworn managers. This amendment mirrors a similar agreement made between the city and the GFFA in July of this year, which reopened their MOU for the 4th time since the original inception of this agreement in 2006. The GFFA MOUs and the fire sworn managers MOUs operate on a parallel plane, and they pretty much follow one another. Similar to the GFFA, the fire sworn managers, who represent essentially 6 battalion chiefs and 1 deputy chief, they've agreed to defer a scheduled cost of living increase for the 3rd time and gradually increase the employees' contribution to PERS by the year of 2015, ultimately bringing that to 3.5%. Also, this amendment contains a retirement incentive of a lump sum of $43,000 to the retiree health savings account of any sworn fire manager who agrees to retire by December 31st of this year. We know of at least 1 fire battalion chief who has agreed to retire, whose position will not be refilled. Others are eligible, but we are uncertain if they will. And if those who do retire, we'll have to make that assessment as to whether to fill that position or not. If it is filled, they'd likely be filled at a lower paying or a lower step, so there'd be additional cost savings there. This amendment will extend the current MOU contract for another 2 years through 2016. We anticipate approximate savings over the life of this contract of approximately $600,000, mainly through the deferral of the cost of living increase that was supposed to take effect in 2013, but also through the permanent elimination of 1 fire battalion chief, which is roughly $200,000 to $250,000 per year. With that, we do recommend that this amendment be approved, and if you have questions, I'd be happy to try and answer them.
Any questions or comments? I have a second.
Can I make a comment?
Go ahead.
I just want to thank the GFFA for their willingness to help out in this difficult time in the city. The fact that they've had contractual obligations with the city for cost of living increases that they have given up willingly over the past 3 years, I think is pretty exceptional. When I tell council members from other cities this, they're just shocked. Maybe I shouldn't say that. I should tell them it's the norm. But it's not always the norm in other cities. And I think that I speak for the whole council when I say that it's very much appreciated. So thank you.
I agree. The GFFA has literally led the way. They were the first to come to us, the first to give up benefits, and I think they've done a wonderful job in the way they participated in the whole issue having to do with paramedics and so forth. Very good job by the rank and file and obviously the leaders of GFFA, and I think it also speaks to the good relations between the management team at Glendale Fire and the rank and file. Any other comments? Roll call.
Council members: Friedman,
Yes?
Menuchyan,
Yes.
Najarian,
Yes.
Beaver, Mayor Quintero.
Yes. Next.
Motion to adjourn the special meeting.
We are adjourned.